Hello, everybody. This is Professor Keith Ross from the John Jay College of Criminal Justice. To all my students, I hope you all are well, safe, and healthy. Um, Today, we're going to be looking at Chapter 7, which is the criminal courts, their structure, and their process. Just a little bit of a side. For the first 6 chapters that we've talked about, we've really concentrated on just one area of the criminal justice system. We've been really talking about police and or law enforcement. And when we're talking about police and law enforcement, really the only legal standard of proof that we're pretty much talking about is probable cause, reasonable cause to believe, reasonable grounds to believe. They all mean the same thing. We are now starting to leave that part of the criminal justice system and getting into the actual court system. And the court system is interesting because there are two legal standards of proof, possibly three if we're talking about civil courts, but since this is a course in Introduction to Criminal Justice, we're really going to just be focusing on the two. Those two, again, probable cause, and then in order to gain a conviction in a criminal trial, the standard of proof is beyond a reasonable doubt. Now, we were talking about the police, and for those of you that remember in those first couple of weeks, I gave you that 12-step criminal justice process where we had the citizen police encounter, we had the arrest, we had the station house processing, then we had central booking. All of that resided with just the police. But now, if you remember 5 and 6, the fifth one was conferral with the assistant district attorney. That's your prosecutor. And then we had arraignment. So there, we're purely in the venue, pretty much, of the courts. So let's talk about the courts. The history of the American court system, our structure is basically structured on the English court system. So our primary role models are English common law. And if you remember, we talked about English common law, differing terms, a term like felony, a term like misdemeanor, things like robbery and burglary. A lot of this was spelled out with English common law. We have also sort of adopted the court system that England has, where we have representation of the state, county, and or jurisdiction, and representation for the accused, and then there is a judge who proceeds over this and makes a determination. Early courts, judicial personnel, the judges, were local influential citizens, so they didn't have legal training. We hope they had common sense, whatever that really means. I'm going to sort of skip around, so I am now on slide 6, which is the state court system. And the state court system and the federal court system sort of mirror each other in the way that they look like. Courts of limited jurisdiction. Now, if we're talking about New York State, a great example of a court of limited jurisdiction is traffic court, because with traffic court, they only focus on one set of rules and regulations, the New York State vehicle and traffic law. They are not allowed to hear anything else. So their jurisdiction is purely the New York State vehicle and traffic law, and location-wise, obviously their jurisdiction is where? New York State. Courts of general jurisdiction. These are general trial courts. And if you recall in class, we talked about this, that for New York State, or let's talk New York City, especially in New York City, there are two types of trial courts. There is the New York City criminal court system, and that would hold trials for what? Misdemeanors and or violations. Then there is also State Supreme Court, New York State Supreme Court, and in New York State Supreme Court, the trials that are held there are for people that have been charged by the courts with felonies. Then we have those appellate jurisdictions. So if someone has been sentenced and they have been sentenced guilty, they can appeal the verdict. And if you recall, we also discussed this, that we're not actually appealing the verdict, but we're appealing the process by which the verdict was rendered. And then courts of last resort. One thing I want to point out, generally in a lot of states, those states have as their court of last resort, they call them state supreme courts. However, New York State operates a little bit differently. In New York State, the highest court, or the court of last resort, would be the New York State Court of Appeals. Anything higher than that, we're now really dealing with federal jurisdiction. The federal court system. We have judges, and we'll talk about who appoints the judges. But again, their system, it mirrors our system, or really what I should say is our system, or the state system mirrors the federal system. There are district courts. District courts are general trial courts. So if something is in the purview of breaking some sort of federal statute, that trial, if the person wants to plead not guilty, will take place in a federal court. If that person has been found guilty by that district court, by that trial court, and they want to appeal the verdict based on the process of arriving at that verdict, they will go to the United States Court of Appeals. And then the very highest court in the federal system is the United States Supreme Court. The United States Supreme Court is the law of the land. It is the highest court in the United States. There is nothing higher. There is nothing that supersedes its power and or jurisdiction. More often than not, when the United States Supreme Court hears a case or hears an appeal, they're not really looking at the process by which a verdict was rendered. Rather, what they're looking at is the constitutionality of the verdict, of the case. Now we're going to go to court participants. One of my criticisms of the criminal justice system is that we pay an awful lot of attention to the law enforcement side. We're talking police, we're talking sheriffs, we're talking corrections. We pay attention to the defendant's side. What rights does a defendant have? What rights does a person who is accused of an offense, what rights do a person that has been convicted of an offense have? A lot of times I feel personally that if there is an issue is that we don't address victims. And even in the PowerPoint, the victim says that they have a marginal role in the trial process. They can testify, but they don't have to testify. However, if their testimony is needed and that person refuses, they can be compelled via subpoena. The reason being, and that reason that they're being compelled is based on the Sixth Amendment, that they have the right to know what charges have been leveled against them, and they have the right to confront witnesses. Defendants must appear at all hearings, and that sort of makes sense. The reason why a defendant must appear is because they are the one accused. They are the one that have the most at stake here. However, although a defendant must appear, must they speak during this trial? The answer to that question is no, because you have a Fifth Amendment right to not self-incriminate. You have a Fifth Amendment right to remain silent, because anything you say can and will be used against you in that court, in that trial. Now let's talk about staff. There are a lot of people that make up these courts. More often than not, the most glamorous job, obviously, is the judge. But there are other people. There are some behind-the-scenes type people, court staff, administrators. And what they are, they're tasked with having the office itself operate. They take care of budget. They take care of hiring. Who are they going to hire to work in that office? If that person gets hired, well, how much do they make? What's their salary? Is there a benefits package? So there is a human resources attached to that. Tracking cases. As soon as a case is brought by the court, we want to know, well, where is it? Has the person been arraigned? have there been any sort of pretrial motions filed by the defense, things of that nature. Records, general information, liaisons with other courts, and liaisons specifically with other government agencies. I mean, think about this. If you have been charged with some sort of offense, don't you want the police officer that affected the arrest and the other police officers that might have been at the scene to be there to say what they saw? Because maybe really when we're talking about it, what we're going to talk about next is when we talk about defense attorneys, what does a defense attorney do? Well, they create reasonable doubt. One of the ways that they do that is by impeaching credibility. We have clerks, clerical work of the office. Anything directed towards the judge will pass through the court clerk's hands first. So if there is some sort of pretrial motion filed by normally the defense team, in order for that to be presented to the judge, the clerk has to look it over first to make sure that it's accurate before the judge looks at it. Because if there are inaccuracies, the judge is not really going to even look at it. And if we tasked judges on proofreading motions, they would have no time to actually sit and hear cases. Bailiffs. Bailiffs provide courtroom security, and they are also in charge of the custody of the defendant. Court reporters, sometimes called stenographers, what they do is they record every word that has been said during motions, during trials. So they are the official record takers of the courts. When juries get sequestered to deliberate, to start figuring out what the verdict is going to be, well, one of the things that they want to do is they want to have all the notes of what happened at a trial. And this is really what the court reporters do. Now, probably the most glamorous position in the court, and one of the most important, are the judges. They are responsible for a wide variety of tasks. They determine probable cause for warrants. Now, if you recall, when we talked about, I believe it was chapter 5, we talked about the court recognized exceptions to the search warrant rule. Well, if one of those exceptions are not applicable, in order for police to search, they must have a warrant. And what police must do is they must gather information, gather enough information where they have probable cause. Well, who determines whether the police actually have probable cause or not? Well, it would be the judge. They determine whether a defendant will remain in state's custody or the city's custody, or will they be released on their own recognizance? Will there be bail? They also determine that if there is bail, well, how much is that bail going to be? And recall, when we're talking about bail issues, we're clearly in the purview of the Eighth Amendment, that what a judge has to figure out is the bail excessive or not? They conduct the rules on pretrial hearings and motions. We'll talk a little bit more about those motions, but I've discussed some of those pretrial hearings already. Things like MAP hearings, things like Huntley hearings, or the Wade Gilbert Stovell hearings. They will also, during these pretrial hearings and during trial itself, rule on the admissibility of the evidence. How much of the evidence and what type of quality evidence is being brought in? Is it applicable? Is it, quote unquote, probative to the case, probative to the trial? Meaning, is there a nexus between the evidence being brought and the offense that the defendant has been committed, the offense that the defendant committed? Decides on this idea of plea bargaining. We'll talk about plea bargaining a little bit later, but real quickly, what is a plea bargain? Well, a plea bargain means is that a defendant will plead guilty to a lesser charge, not the charge that they were initially charged with by the courts. And probably one of the more important things that a judge gets to do is that if a jury or a judge renders a guilty verdict, well, it is incumbent upon the judge to figure out what that sentencing is going to be. I'm going to skip slide 12. I'm going to go straight to 13. Prosecutors. For me, and maybe it's a mistake, but at least in New York City and New York State, we can use the terms prosecutor and assistant district attorney, or for short, ADA, interchangeably. They both do the same thing. Basically, what they are the representative of the state. They are representative of the person that has made the accusation against the defendant. And if the person chooses to not press charges, uh, the state can proceed with its own case, and they will then represent, at least in New York State, PSNY, people of the state of New York. There is a presumption that the prosecutors will be fair and impartial, and it is incumbent upon the prosecution to prove guilt. A person that is accused of an offense in the American criminal justice system is presumed innocent until proven guilty beyond a reasonable doubt. So when we're talking about criminal trials, regardless of whether a person has been accused of a violation, a misdemeanor, and or a felony, they must be proven guilty beyond a reasonable doubt in a criminal trial. If we're talking about civil trials, they have to be proven guilty with a preponderance of the evidence. Now, I think I've stated this before. When we're thinking about civil trials, a real easy one is think about Judge Judy. What does Judge Judy do? She listens to two sides of the story. And then what she does is she figures out which side tips the scales of justice just a little bit, tips it to 51%. If one side tips the scales to 51%, that is considered to be a preponderance of the evidence. Roles and responsibilities. They decide which cases are to be prosecuted. Now, a lot of people sort of don't understand this, but let's think about this. In order for a police officer to effect an arrest, a police officer must have probable cause. What is probable cause? Probable cause is really easily stated is that that an offense has been committed and the person who is about to be arrested probably committed that offense. Probably. Do we 100% know that this person did? No. But the totality of the circumstances at the time and place that this offense was committed, a reasonable person would believe that the person who's about to be arrested committed this offense. Now, as a prosecutor, as an assistant district attorney, what must they do? Well, in order for them to gain a guilty verdict, they are not using probable cause. The legal standard of proof that they use is beyond a reasonable doubt. So, although the merits of the case might warrant probable cause, there might be something in there that does not merit beyond a reasonable doubt. Prosecutors will evaluate evidence. They are the ones that actually determine charges. Police officers will determine charges. And once they have brought them, but they're only determining charges for the police department. Now, a district attorney has options. Well, they can choose to not prosecute a case, as we just sort of talked about. In New York City, what that's called a decline prosecution or 343ing a case, meaning that the prosecutor is looking over everything that the police officer did, all the paperwork that was submitted, uh, maybe conferrals with that police officer, and maybe there was probable cause, but maybe there's not enough to gain a conviction. But district attorneys can also look at the charges that the police have submitted and say, well, you know what? I don't see this, but I see this. Maybe the difference is a police officer charges someone with a robbery. Well, at least in New York State, how do we define what a robbery is? Well, robbery is a larceny, the removal of property without permission or authority to do so, with either the use of or the immediate threat of force. Well, maybe a prosecutor is looking through all the paperwork, and what they see is that they don't see a robbery, they don't really see force. Maybe the victim of this offense refused medical aid, something to that effect, some sort of technicality. But they do see, let's say, a grand larceny, also a felony in New York State, but a lesser felony than robbery. So they can choose to do that. They could choose to concur with the police officer. Good work, Officer Ross. The way you wrote this up, I see the robbery as well. Or maybe they can actually upgrade the charges. You know what, Officer Ross? You did a good job, but you shouldn't have charged robbery in the second degree. You should have charged robbery in the first degree. Something to that effect. And they prosecute cases. On the other side, we have defense attorneys. And what are defense attorneys? Well, they are advocates. They are the ones that represent the person that has been accused. They are the representative. They are the ones that what their sole job in court is to create a reasonable doubt. I've used this example before when we're talking about reasonable doubt. The O.J. Simpson criminal trial, that one piece of evidence, the glove, if it don't fit, you must acquit. That one piece of evidence, since it didn't fit over O.J.'s hand, was enough reasonable doubt, that 1% that he might possibly not have committed this act, that led the jury to find him not guilty. Now, defense attorneys, really, when we're talking about constitutional issues, defense attorneys sort of reside within the Sixth Amendment. That we have a right to confront our accuser. We have the right to cross-examine witnesses and our accuser. We also have the right to obtain witnesses in our favor. Well, the Sixth Amendment also says that I have the right to counsel. I have the right to representation. Now, depending on what we're talking about, there's this concept called the absolute right to counsel. That once the courts have charged me, and if you recall, what is that called? That is called an arraignment. So once the courts have charged me, I have an absolute right to counsel, meaning that if I want it, I can have someone as my advocate, someone who knows the law better than me, someone to represent me and represent my interests. Now, if you recall Miranda warnings, you have the right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand? Yes, I do. You have the right to an attorney. If you cannot afford one, one will be appointed to you at no cost to you. So, regardless of my ability to pay for representation, it is incumbent upon the states, it is incumbent upon the courts to provide me with representation if I need it. So we're on slide number 15, representing indigent defendants. Someone who is indigent does not have the resources to pay for an attorney. So if we don't have those resources, I don't have enough money to pay for representation, well, I don't have to fret because I will have representation. The ability to not afford an attorney does not preclude the ability to retain an attorney, to retain counsel. Now, there are three types of systems that we sort of talk about. Contract system, utilized when there is no public defender. And usually what this is a private firm that contracts with whatever jurisdiction, a city, a county, a state, whatever. They charge a flat fee to represent the people that have been accused. However, there's not enough resources to mount an effective defense, because really what you have to do is, when we're comparing numbers, we have to compare the number of people arrested versus the number of attorneys available to represent that number. Now, you'll get representation, but there might be a difference between getting representation from the state and being able to retain a lawyer at $700 an hour. Assigned counsel, 18B. Now, in New York State, when we're talking about 18B attorneys, these are private attorneys who volunteer to represent defendants. They tend to be younger and less experienced, and they're not paid all that well. And then we have public defender system. In New York State, we're talking about the Legal Aid Society. These are full-time employees of the trial courts. They have very high caseloads, and they don't really get much respect from the profession of lawyers because they're sort of seen as the bottom tier of what a criminal attorney does. So getting back to the criminal justice system, We talked about number 6, that initial appearance. That initial appearance is called an arraignment. Why do arraignments happen? Well, because I have a Sixth Amendment right to know the charges being leveled against me in the courts. Now, if you're looking at slide 16, that's right in the top, that I have that right to counsel. I have the right to remain silent. So my lawyer can talk to me. Now, one thing that I want to sort of maybe just mention, that lawyers have what's called a fiduciary responsibility, that no matter what their defendant says, they have to represent their interests if they choose to take the case. And one of the other things is that during arraignment, bail can be offered. And if it seems that the judge is giving an excessive bail, well, the defense attorney can say something, Judge, I think this seems excessive. I don't think my client is a flight risk. I don't think that the bail that you're mentioning merits to what the offense has been committed, that it seems, quote unquote, excessive. Misdemeanor cases, defendants may plead guilty and face immediate sentencing. And think about it, when we're talking about misdemeanors, a misdemeanor, the maximum sentence that a judge can impose is what? 1 year, 365 days, usually. For felony cases, however, defendants are rarely allowed to enter pleas. Now, if you recall, after an arraignment, when we're talking about felony cases, there are some hearings that take place. We have that preliminary hearing, and then we have grand jury hearings. And those hearings really evaluate evidence, and they evaluate this idea of probable cause. There is a 48-hour rule, normally giving the system needed flexibility between the moment the person has been arrested and when that person is going to be arraigned or told the charge is being leveled against them. Now, there can be extraordinary circumstances. Let's say a defendant has been hospitalized and they're not conscious. Well, then obviously you can't arraign someone that is not conscious because they are not of sound mind at the time that you're doing this arraignment. Pretrial releases, release from custody while awaiting trial. And for those of you that have been following this, these bail reform issues are releasing more and more people that are awaiting trial, and also people that have been convicted. The Eighth Amendment prohibits against excessive bail, but does not guarantee the right to pretrial release. So this idea of pretrial release is a privilege. It is not a right. The majority of arrested individuals will eventually be released before trial or the final adjudication, rendering that verdict by the court. You guys can read 18, 19, 20, 21, and 22. I'm going to go straight to 23. Well, we talked about this idea of arraignment, and we talked about this idea of pretrial release, that people will be people, or the accused, I should say, defendants can be released prior to trial, especially when we're talking about felony cases. Well, why? Why is this? Well, because there are a lot of steps that must be taken prior to going to trial. And one of the really important things is this idea of grand jury. Now, just to backtrack a little bit, at least in New York State, and this is something I've mentioned before, no matter what I've been charged with, if I'm a defendant, if I've been charged with a violation, a misdemeanor, and or a felony, that very first arraignment, my initial appearance in court, will take place in New York City criminal court. Now compare this concept to the concept of where trials are being held. That if I'm accused of a violation and or a misdemeanor, my trial will also be held in New York City criminal court. However, if I've been accused of a felony and I plead not guilty, my trial will take place where? That will take place in New York State Supreme Court. Grand juries are convened, at least in New York State, in New York State Supreme Court. And basically what it is, it's a body of citizens called by the prosecutor to investigate conduct of public officials and agencies and criminal activity in general. And more importantly, what they're tasked with doing is determining whether probable cause that a crime has been committed. And the evidence that has been gathered by both the police and the prosecution is admissible. They meet in secrecy. Witnesses can be called to testify. The exclusionary rule does not apply. When we're talking about this exclusionary rule, the fruits of the poisonous tree, this is more the purview of those suppression hearings or pretrial hearings. We've talked about this before. There are some important numbers to remember in New York State grand juries. The first is this number 16 to 23. When we're talking about 16 to 23, this is the amount of people I need to actually convene a grand jury. I can have a minimum of 16. I can have a maximum of 23. I could have anywhere in between. I could have a grand jury comprised of 19 people. Well, who determines this? This is going to be determined by a judge. Out of that pool of 16 to 23 people, let's say I have 23 people in my grand jury, I need 12 of the 23 people to evaluate everything that they've heard, everything that they've seen, and said, yes, probable cause does exist, that the person who has been accused of this offense probably did it. If I have 12 people that can say, yes, there is probable cause, this is called an indictment, or sometimes otherwise known as a true bill. The prosecutor's decision to prosecute. Prosecutors do not always file identical charges in similar cases, media-worthy cases, heavy-duty felonies. Now, I'm not really crazy about heavy-duty felonies, but if we were talking about heavy-duty felonies, we're probably talking about major felonies. I think I've mentioned this in class. I used that acronym, Mr. Rab steals cars, where we're talking about murder, manslaughter, rape, robbery, felonious assaults, burglaries, grand larcenies, and grand larcenies of an automobile. You might want to tack on arson, maybe kidnapping to that as well. Those were probably considered to be heavy duty cases. Then lightweight felonies. Off the top of my head, maybe something like criminal sale of a controlled substance. That is a felony, but it's probably a lighter weight felony, or it's a less violent felony than, let's say, something like sexual assaults or robberies. They do not prosecute all cases brought to them by police. We've already mentioned this, that there could be a lack of evidence. And there is this idea of differential treatment. Media can make or sort of push prosecutors in a different direction than they might not have gone if there was no media concentration. Or social status. Sometimes one of the criticisms of the criminal justice system is that depending on your social and or economic status, the criminal justice system treats you differently. Preliminary hearings. Purposes to determine probable cause. Now, at least in New York City and New York State, we talked about preliminary hearings. Preliminary hearings are convened where? In New York City Criminal Court. And really what they're tasked with doing is looking to see whether there is enough probable cause to go to that grand jury. I think what the book is talking about more when we're talking about preliminary hearings are those pre-trial or suppression hearings. This concept of discovery. Let's think about that 12-step criminal justice process that we talked about early in the semester, and I sort of mentioned in this video. Police officers effect an arrest. Well, if they effect an arrest, they have to gather evidence. Officer, someone stole my cell phone. That's the guy that did it. Are you sure that's the person, that guy that did it? Yes. He did it about 2 minutes ago. He ripped my cell phone out of my pocket. Well, what's going to happen? Well, we've already established that at this point in time, the police officer has no reason to doubt the credibility of the victim So there is probable cause to effect this arrest. So turn around, face the wall, place your hands behind your back. I put the handcuffs on him. As discussed in another chapter, chapter 5, I can search this person incidental to lawful arrest. Well, if I can search him incidental to a lawful arrest, let's say I pull out the cell phone. As soon as I pull out the cell phone, the person says, "Hey, that's my cell phone." I continue my search. Let's say I pull out 4 decks of heroin. This is a scenario I've used over and over again. Well, I'm going to as a police officer, I have to document all of this. So I'm going to be doing paperwork. Well, at least in New York City, I'm at least, at the very least, probably going to do an arrest report, probably going to do a complaint report as well. Well, so I'm filling out all of this paperwork. Well, some people are going to be interested in the paperwork that I have filled out. Who's going to be interested? Well, the prosecution is definitely going to be interested in the paperwork that I've filled out, because what does the prosecutor do? Well, they are going to decide whether they're going to move forward with the case, that I've started via this arrest. There might be someone else that's interested. And who else is going to be interested? Well, the defense team, because what the defense team wants to do is they need to look at all the paperwork. Because what does the defense do? Well, they represent the accused, they represent the defendant, they are the advocates. And if they are representing, they need to know what they're being accused of and what took place. What the prosecution does is that they take all of the investigation that the police have conducted. The prosecution might conduct its own investigation on top of what the police have conducted. All of this is part of the prosecution's case. The defense team gets to discover what the prosecution has, all the pieces of paperwork, any interviews that the police have conducted, any interviews that the prosecution have conducted. So the legal motion that allows the defense to discover the basis of the prosecution's case, this is called discovery. Seen as providing a level playing field for both parties in this adversarial system, that we have the prosecution, we have the defense. They're sort of at odds with each other. They're opponents. What does the prosecution want to do? They want to prove guilt. What does the defense want to do? They want to raise a reasonable doubt to get their client off, to find their client not guilty. Entering pleas, an individual's response to a criminal charge. The plea for felonies usually entered at arraignment, misdemeanors, at least in New York City, as well. There are at least 3 different types of pleas. I can plead guilty to what I'm being accused of. I could plead not guilty, that I did not do what I'm being accused of. And then there is a third plea that we don't really talk about too much, and I don't really find it all that interesting or important, but I wanted you guys to hear it. This concept called nolo contendere, meaning no contest, that I'm neither pleading guilty nor pleading not guilty. I just want this to be over. If there's going to be a sentence, give me the sentence and let me go on my way. Usually nolo contendere pleas are entered for violations, where the most, at least in New York State, the maximum jail time would be 15 days. I want to point out, and I say it over and over again, what is the one plea a defendant can never plead? Innocent. No one can ever plead innocent, because there is a presumption of innocence, that I am innocent until proven guilty beyond a reasonable doubt. Plea bargaining, or this idea of bargain justice. It's an interactive process. The prosecution and the defense attempt to arrive at a mutually satisfactory disposition of case without going to trial. Well, let's think about it. Agendas. Again, we've mentioned this. What's the agenda of the prosecution? The prosecution wants to get a guilty verdict. What is the agenda of the defense team? They want to get a non-guilty verdict. Sometimes what happens with this idea of plea bargaining is that a person who has been accused of an offense will plead guilty to a lesser charge. So maybe the police had charged a robbery. The prosecution charges a grand larceny, which is a felony in New York State. The prosecution and the defense get together and they come to this mutual decision that the prosecutor will charge petty larceny, which is a misdemeanor, and the defendant will plead guilty. Why would a defendant plead guilty to this? Because, again, in misdemeanors, the maximum sentence is a year. When we're talking about felonies, the minimum sentence is a year plus 1 day, but could definitely be more. In grand larceny cases, who knows, depending on a defendant's past record or what have you, or maybe the judge's view of how this offense took place, could be more, could be 3 to 8, whatever the case may be. I think that's going to be it for this chapter. The next chapter, we're going to sort of piggyback on concepts that we've talked about already, and that'll be chapter 8, the trial. I wish you all the best. Have a great day. Take care.